Good morning. We'll call the Wednesday morning, May 11th, 2022 meeting of the Criminal Justice Committee to order. With roll call, please.
Mr. Hess?
Present.
Mr. Long?
Present.
Mr. Lear?
Present.
Mr. Snipes? Ms. Peters? Ms. Parker? Present. Mr. Fairfield?
Present.
Mr. Carrico?
Present.
Mr. Eckhoff? Mr. Swanson? Mr. Kirkstra?
Present.
Mr. Hunter?
Present.
Mr. Collins? Mr. Smith?
Present.
Mr. Gowler? Mr. Wheeler? Mr. Seroy? We have a quorum.
Okay, I have not received anything for public comment. Is there any public comment at this time? Ms. Peters, any public comment? Moving on to approval of the minutes of April 12th, 2022. Mr. Long, second by Ms. Parker. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. I'd like to entertain a motion to move up the coroner so he could get back out to this section. Mr. Long, second by Mr. Carrico. Mr. Gessner. While he's on his way up here, I got a text late last night from the sheriff, and the sheriff and his whole staff, along with the coroner and his staff, are going to be tied up today with the coroner, so the sheriff will not be here. President, not the president, thank you. No, they better not be tied up with you.
I don't want them around my area.
Yeah. Your report, sir. I'll take a motion to combine and approve his reports. Mr. Hunter, second by Mr. Smith. Okay, sorry, go ahead.
No problem at all. You see, in April, our calls have gone down, which is good. It's not summer yet, but you know, it's gone down with our autopsies. We're down. Basically, even as we go down, everything else is kind of really going down, which is really happy to have that. We don't usually get that too often. Even as far as down as the overdoses have been down right now. Excuse me. Am I on?
Now you are. Thank you.
Okay.
Thank you, Janice.
Anyhow, the overdoses have been down, and we've been out teaching now, so we're able to go to different places and also hitting the news media a little bit with the amount of ODs we had. I don't say it's going to help, but I hope it does help a little bit. We're at 17 overdoses right now with just one pending, so we're holding back on that pretty good. So I'll take any questions you have on that at all.
Any questions, Mr. Long?
Thank you, Chairman. One point in time, you talked about trying to track how much Narcan is being used. How successful were you with that?
The problem is it's getting. I only keep track of what the law enforcement do. As far as getting the rest from the emergency room department, we just had that. Eric, do you remember the figures on that? It's outstanding. Roughly about 19 saves, if not more, so far.
I noticed the ads were on the radio about you can go to our public health department to get Narcan now. Is that true?
Yes.
Yeah.
Yeah, and they have it throughout some of the stores in the area here, tobacco stores and stuff like that.
Yep. Well, thank you.
No problem.
Mr. Hunter.
Chairman,
drift.
Coroner Gessner, I know you can't give me any specificities, but it may be too early. I got a phone call yesterday about a guy dropped dead over on the north side. I don't know if it was Indiana Avenue or whatever. You have any information on that at all?
No, I don't.
Yeah, I know the police were on site and they covered the body up. So, and I knew the guy, so I was just wondering if you had any information on that.
No, I'm looking back at. Nope, nothing.
Okay, thank you.
If something comes up, I'll let you know.
Any other questions on the reports? We have a motion, a second. All in favor say aye.
Aye.
Opposed, same sign. Motion carries.
That's it. Appreciate it.
You got on here about a change in policy? Is that not you?
No, that's under old business or new business.
Oh, Oh, okay, I'm sorry. You're fine.
Am I fine?
Yeah, you're fine.
Thank you, Mr. Chairman. Thanks for getting me ahead of schedule here.
Yep. I don't see the chief. Yes, he is. Judge Cunnington. Up next, Chief Judge. With the chairs, it's hard to see back there
Yeah,
anymore.
it's fine. I just walk in a couple minutes late. Good morning. Just have a couple things to report this morning. First, on our case management system committee has been meeting regularly every 2 weeks. We are putting together the request for proposals, and we plan on having that completed by June 1st and go out to solicit those proposals. And I'd like to thank Mr. Long, Mr. Fairfield for attending our meetings. Hopefully they're getting some information to bring back to the board. But at this point, we have all the stakeholders putting in they're reviewing their respective sections of the RFP, and they are outlining what they think is important as far as their particular area is concerned. And then we'll put that back together, and that will be our RFP to go out to the various vendors. The other thing I wanted to report on is on the Cash Bail Act that I know Chairman Wheeler talked about at last meeting, and at the Chief Judge's meeting in Chicago a couple of weeks ago, we decided that we're going to quit crying and just deal with it. So I think that was the words of our chairman up there. And that's what we're doing. I've asked Judge Dickinson to put together a committee of the stakeholders, which is going to include, all of our department heads, and come together and go over what this act is going to require as far as what we're going to have to do here in our county. The one thing that is pretty obvious is that we're going to have to hold a full court session on Saturday. Currently, when we go out to the jail, we have a judge, we have a state's attorney, and then we have a public defender. And those three persons then conduct the weekend bond court out at the jail, usually a 30 to 60 minute process. I think the state's attorney spends a little more time because they have to review all the reports, but it's a fairly short process. Under the new act, it looks like it's appearing very much like we're going to have to hold a full court session at the courthouse with court reporter and a clerk and a bailiff and a security, and obviously that's going to cost more money. So I don't think we're going to have to hold it on Sunday, but at least on Saturday afternoon we will probably have to have some kind of session. So that's moving along. We're still hoping for a trailer bill after the election. We hope Springfield will correct some of the issues that are arising with that act, because it is going to be onerous. And there's a lot of questions. What do we do with the people already in custody that have cash bonds? What do we do with the hundreds, if not thousands, of bench warrants that are out there now? Those are all questions that were not addressed with the legislation. So, any questions?
Mr. Hunter had a question.
Yes.
Thank you. It's good seeing you.
Good seeing you, sir.
R6.
Yeah, D7.
Thank you. Got a question. Your first comments about the case management system and you putting an RFP together. Have you? Are you considering a consultant to make sure that your RFP will meet the needs of the county and the system, or are you interfacing with other entities, other counties, to make sure that you have everything that you need in terms of that RFP?
We're doing the latter. We decided not to go with a consultant at this stage. It doesn't mean that we won't look to a consultant once we narrow it down and get to the point where we feel that a consultant might be helpful and worth the expense. We didn't think we needed to get a consultant on board from the get-go. There are proposals, RFPs out there that other communities have worked through and completed and have their systems installed, so we've basically been copying from what's already been done just to save money.
Okay.
And then we all are also checking with other communities. I know our team has visited 4 other counties and looked at their systems. And then we have a team, a smaller team going to Indianapolis, I believe it's next weekend, and they are going to listen to a presentation by Tyler Technologies. They're the #1 in the state right now, and they are going to set up a special session just for Kankakee to meet with our people and go over what's going to be involved in that process.
Thank you.
Okay.
Mr. Snipes.
Judge, just a question. Under 725 ILC 5110-61, it says, state as follows: the court enters an order for the detention of a defendant pursuant to subsection E of this section. The defendant shall be brought to trial on the offense for which he is detained within 90 days after the date on which the order for detention was entered. If the defendant is not brought to trial within 90 days prior 90-day period required by the preceding sentence, he shall not be denied a pretrial release, which means it doesn't say that felonies are exempt or whatever. However, after I was investigating this, before I could contact the representatives and the senator as I was drafting something, I read the case of Peoples versus McKinstry, where the Third District Appellate Court gives they remand the case and give some type of restrictions as to, or some type of guidance, let me say, not restriction, but guidance as to this 90-day thing. You might not be able to answer it all in one, but is there, with that case being kind of remanded back here, how would you suggest we kind of hit a language where we're not letting felonies out based upon this statute and just misdemeanors?
Yeah. First of all, with regard to that case, the McKinstry case, I've not read it, but I don't think it applies to the 90 days because the law is not in effect yet. So there couldn't be any appellate decisions on that particular provision. They may be talking about our current 120-day
120, that's what it was, yeah.
statute. But and Mr. Rowe can speak to this as well, but the 90 days is going to be a problem. I mean, it's not. The detention cases are going to be the murders, the rapes, the domestic batteries, aggravated domestic batteries. Those are going to be the ones that the state's attorney is going to hone in on as far as detention hearings. But yeah, that 90 days is right now it's firm. So they're going to be hustling to get everybody to trial. Now, there is an exception if the defendant moves to continue, which typically happens because they're not ready, then that does extend the time. But that's all going to be a issue that we're going to address.
Mr. Hunter.
Thank you, Mr. Chairman. That brings up something. Chief Judge Cunnington and State's Attorney Rowe, this is something for you guys to consider. Something for you guys to consider in terms of cashless bail and other kind of stuff that Snipes was referring to. Had you guys think about having a committee of the whole to discuss some of this stuff?
Yes, I've appointed Judge Dickinson to man that committee, and he is pulling together the stakeholders to discuss exactly what you're talking about.
I'm speaking in terms of us as legislators, you know, for you guys to make a presentation and we can give you all these questions we got, and you guys can give us the implications and maybe there could be some recommendations coming out of it. So
sure, I think we'd be happy to do that. We're still in the let's understand what's in the law, and we were waiting for a trailer bill, quite honestly, and Springfield didn't do it. So like I said, we're just gonna go ahead and move forward. But you know, we can make a presentation. It's going to be, you know, we're still working through all of the various sections of the law, but so I would say later in the year before it takes effect, we could do that.
Thank you.
Any other Mr. Snipes?
Yeah, and that, when I was just thinking about the 120 days, you generally can extend it for another 120 days, but it looks like there's gonna be some restrictions. So among this 90-day, even with the speedy trial, there's that, it looks like it's gonna put a burden on the courts.
Yes. and the state.
And the state.
Yeah. Well, and the public defenders as well, because they've got to, they've got to be ready for trial in 90 days as well.
Anybody gonna fund this, or is it gonna be a? Well, that's the question I automatically know, but no funding is coming from the state to help the county in the event that we have this backload and dealing with criminals who's gonna be back on the street and all that.
I have not seen any money forthcoming.
I'm gonna turn your mic off before you ask another question.
I'm not even sure they realize that we're gonna have to have additional court sessions, but it was all passed, in the middle of the night.
Middle of the night, yeah.
Yeah. Okay,
Thank you.
thank you.
Up next, Circuit Clerk, Ms. Cianci. Don't see her. Take a motion to approve her report by Mr. Fairfield, second by Ms. Peters. All in favor say aye. Aye. Opposed, same sign. Motion carries. Up next, Mr. Rowe. Take a motion to approve or combine and approve the reports. Mr. Snipes, second by Mr. Long. Good morning, Jim.
Good morning. You see the grand jury returned 39 true bills, brings us up to 254 on the year. So we're down, which is good. We're also happy to announce we're caught up with the backlog of cases that we were waiting to get to the grand jury. You can only put so many cases through grand jury before, you put 40 cases through 50, you're really running a long session there. And it's hard to keep the grand jurors engaged. So in the past, we tried to shorten that so they weren't there all afternoon. What we did this year, we start earlier in the morning. So they have a morning session, and then we can come back from lunch and finish up. So we're all caught up, and I'm guessing, 254 thus far. We're on pace to hopefully have fewer felonies indicted through the grand jury this year. So, which is a welcome sign.
Yes. Questions or comments on the reports? We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries.
All right. Anyone have any questions?
I had one that asked me earlier, and Sandy's not here. On the collections from you guys, do you think we're just catching up? Is that why it's so low?
No, I think it's a couple reasons. First, there's no incentive anymore to pay court fines, where in the past you could have your driver's license revoked or suspended due to unpaid fines. The state has removed that. Secondly, most individuals now, when they are convicted of an offense, their fines are waived. That's under a law that passed, I believe, a year or two ago. So in those rare instances where a fine is assessed, it's virtually impossible to collect it. And rarely now are fines even calculated at the end. Most of them are waived. And then to add to that, probably about a decade ago, the state started the Illinois Debt Recovery Program. IDROP is what it's called. And if someone owed a debt to the state, to a municipality, the entity could put that into the comptroller system for the state of Illinois. And when their tax return was coming back, or if they were a state employee, they would garnish it from either the tax return or their payroll. Well, when COVID started, the state put a halt to that. I think it was Comptroller Mendoza. And last year, they stopped it again, and she announced recently they weren't going to do it this year either. So in the past, we would have a significant amount of fines being paid through that IDROP program, and that just isn't happening anymore. So the ability to collect those fines is reduced substantially. And I think we're seeing it across the board. And it's not only Kankakee County, of course, it's probably just about every county in the state at this point. So, and that, that stuff has an impact. It shifts the burden of the criminal courts onto the taxpayers. It hampered our ability for a long time to provide even a teen court for kids. It reduced revenues that come in to prevent gang violence. So those things have real impact on public safety, at the street level.
Mr. Hunter.
Thank you, Mr. Chairman. Mr. Rowe, could you give me, or give us, just an overview of some of the youth initiative programs that you're involved in?
We still have the after-school program going on, the mentoring program, the mental health component to juvenile court that the board approved to some space for. I think it's last year. That's going along pretty well. We should be coming up on a year pretty soon here and be able to provide a report how many kids have been serviced. But I know that from what I hear, the rapport that the counselor is developing with the kids is really positive. So it seems like that's paying some dividends. We of course have the fishing club. That's not just an excuse for me to leave work early. That's probably one of the most popular programs. People have been very generous with donations, supplies, and covering food and stuff. We have teen court going on. Yeah, I think that's about it.
Thank you.
Mr. Snipes.
Thank you, Brother Jim. Before I hit into that question, let me thank you for, I guess, being this, being a state's attorney that's kind of proactive in kind of reaching all tiers of the community, especially the youth. At some point in time, I thought that you were going to be licensed as a minister, hearing you preach to all of these different functions and things of that nature that you do so well. As you know, I'm a tickler, especially if it's when it comes to the 18th district where we have the gun violence. And there's a couple times I showed up and asked the courts to consider the strongest sentence possible for these individuals that take someone's life. And I am disturbed when I'm looking at against the 725 that I just quoted. And then after I read the McKinstry case, not that was anything wrong with the McKinstry case, but now if they was to put in a speedy trial, it's like you're a little bit restricted as to, you got to jump through some other hurdles in order to kind of get additional time. This bearing on the court, because they're going to have to deny it following the guidance of the courts and then also the legislator. How can we fix it where it will work for your office, the judge's office, and yet do what I call service to the citizens regarding public safety? Because I know it would be disturbing if all of a sudden they walk in that court and then they see this murderer out and you asking someone to be a witness in the case, and they're saying this person is at my house next door. How the variables. Can you kind of elucidate to?
I don't know if I can elucidate. So the McKinstry case is a completely different topic than the 90-day requirement in the statute. McKinstry dealt with a speedy trial demand, which they had 120 days. Normally in Illinois, you can get another 120 days if you're waiting on DNA. In that case, the prosecutor, from my reading of the record, the prosecutor wanted additional time to do some additional testing of the DNA. So that continuance was granted. The appellate court has come back and said the prosecutor had the DNA results, so the state was not entitled to another 120 days. So that was a speedy trial demand. And under speedy trial, if you're not brought to trial within that time period, the case against you is dismissed. So a lot different than the 90 days. Under the 90 days, it's still tragic. A murderer could be released, but the case would not be dismissed against them. So a little bit, difference there. The problem with the 90-day requirement isn't only that it creates probably an unworkable requirement to bring a murder trial, for instance, to trial within 90 days, but you have a state crime lab that is backlogged significantly. So when we submit DNA to the crime lab, it may take 5 months before we get the results. I've had fiber analysis take up to 2 years. So it puts the state in a position where you could have a very violent offender who you don't want back out on the street, and you have to go to trial within 90 days. And maybe you don't have your DNA evidence. So do you go to trial now and put forth less than your strongest case because you don't have DNA evidence that ties them to the crime? Or do you go to trial without DNA evidence and later on it comes back and it's exculpatory, and God forbid you just convicted someone that was innocent because you didn't have the ability to wait on that DNA? Or do you say, like the state, like the law would require, do you say, well, we're going to wait on DNA judge, so put the murderer back in the community?
Right.
That's the situation the state legislature has created here. You're either going to wrongfully convict people, or you're going to lose trials where people are guilty because you don't have the evidence that you need, or you're going to release murderers back out onto the street.
Right. And from a novice layman's perspective, what I was looking at is 120 minus 90 is 30 days. So that means even if that person, if they were still retained or after 9, they only get, if they had a motion for speedy trial with no continuances, you only got 30 days to operate in order to try to get that other 120 days that you may not be able to get unless you jump through hurdles. So it's like it puts you in a constraint, considering that if you got 20 people, somebody looks like they're gonna walk.
Yeah. Well, if they're released, if they're out of custody, then their speedy isn't 120 anymore.
It's 160.
So you get into a situation where you're just having to make, pick one of 3 bad choices every time. Hopefully the legislation changes. I mean, I can't imagine, I mean, our local crime lab is gonna shut down for a while for repairs. So all the evidence will be processed out of one lab, in Chicago, instead of the Joliet lab for probably a year or 2. That's gonna create a more significant backlog in DNA and fiber analysis, ballistics. So it just created a terrible situation. And to have to go 6 days a week is gonna put a significant burden on the whole system. Mr. Pennewick's gonna have to have someone there. I'm gonna have to have a prosecutor, a clerk or 2. Now you don't go and just give a proffer of the facts to the judge and have a bond set. We're gonna have to prepare all of our discovery packets in the morning. We're gonna have to prepare official charges, get them filed, and if we want the person detained, file a whole petition, which means you're gonna have to include in that position all the reasons they should be detained, all the evidence you have against them, their criminal history, have to look up how many times they failed to appear in every case. So this is not gonna be a 1 hour or half-hour proceeding anymore. It's probably turning into a half a day for my office. So.
One of the people to kind of hear this, because that's what we're about to come up against.
It's about to be really bad in January, and they're gonna blame prosecutors, they're gonna blame judges, gonna blame defense attorneys, they're gonna blame the police, but they need to blame the legislators.
Yep.
Thanks.
Thanks, Jim. Up next, Mr. Pennewick. In your package, you have a copy of Mr. Pennewick's monthly report. Take a motion to approve. Mr. Long, second by Ms. Peters. Morning, Ed.
Good morning, Roger.
Comments on your report, sir?
Good morning, everyone. I have no comments. If anyone has any questions, I'll be happy to answer.
Any questions on the report? I'll make a comment. The top 3 all dropped.
You know what, like I said, I'd love to take credit for that, and I will take partial credit, but so it's, the criminal justice system is fluid, it's variance, it all depends, we're back, we slow down in the summer sometimes because of vacations, and, everyone's gonna be gone, so you just never know what actually causes the delays or the reduction or the increase, but no, it's definitely a good thing, and then hopefully it keeps going forward.
Good. We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries. What else, sir?
Just real quick, I want to say something, so I seem to earn my pay this morning, but there is also, Mr. Snipes, the Supreme Court put timelines on all cases, criminal cases, civil cases, and so forth. 30 months for felonies, I believe, if I remember correctly, and there's all these timelines in place. No more judges, no more clerks, no more state's attorneys, no more court reporters. It's all unfunded, and it's going to also have a severe ramification as we go down, as we move forward on that also. So that's another problem that we're going to have to deal with as we go forward. That's all I have.
Okay.
I had to say something this morning. Thank you.
Thank you. Take your blood pressure medicine. Probation, Mr. Latham. In your package, you have a copy of the monthly report from Mr. Latham. Take a motion to approve by Mr. Fairfield, second by Mr. Smith.
Sorry, I'm getting slower. Good morning.
Good morning.
I have nothing to add to the report, unless there's questions.
Any questions on Mr. Latham's report? We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries.
Quickly, I'll start with good news first. The state budget, fiscal year 23 budget, we got full funding for our salaries for probation, which included COLA, cost of living increases, so that's good news. We're good through June of next year. The bad news I guess you want to say is a pretrial update. Our Iroquois office is in phase 1. They're doing, the state's taking over in 3 phases, as I've kind of talked about before. Kinky office is in phase 2, Iroquois office is phase 1. They started posting for those pretrial positions that the state will have, and they're starting out at about $2,000 more than we do. Not a lot, but when I can't get applicants now, we're competing for the same group of people. It's not going to help us at all. And I know we've talked a lot about January of 23. The Kinky office especially, the numbers are going to soar in pretrial. We're going to be responsible for that until the state takes over. I think earliest is January of 25. So right now, out of 4 pretrial positions, I have 2 filled and 2 vacant. If we would have kept pretrial with the numbers, I would have asked the state for at least 3 more positions. So we're going to use 7, or we needed 7 to supervise these numbers that are going to start coming in. We're only going to have, right now, we only have 2. And it's going to be hard to even, we're getting to that range now, we're in May, where you start getting a little more nervous every month because we're getting closer and closer to that hitting. And obviously that'll be part of the conversations of Judge Cunnington, the committee that's being put together. I had to figure something out, but I've been talking about it, but now I'm starting to get that bad feeling in your stomach that and then that comes out last week, the posting for the Iroquois position, and then you realize it's not helping us. So again, like with everything with this new no cash bail taking effect, I'll keep you updated.
Any questions?
Easy.
Thank you, sir.
All right, thank you.
Okay, in your package you have a copy of the Sheriff's monthly report. Take a motion to approve that. Mr. Lear, second by Mr. Kirkstra. All in favor say aye. Aye. Opposed, same sign. Motion carries. Anita, are you doing this one?
The person was supposed to be
Terry?
but I don't know.
The amending section 3855.
I'm sorry, I haven't seen anything. I haven't seen this before. I have no idea what it is.
Mr. Wheeler was supposed to be on Zoom, but he's not here. Do we want to table it?
I don't know. I guess we have to.
Okay, let's take a motion to table this amendment. Mr. Long, second by Ms. Parker. All in favor say aye. Aye. Opposed, same sign. Motion carries. Any other old business to come before the committee? Any other old business? Any new business? Mr. Long.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I'd like to mention that on the 19th of May at 11 o'clock in the morning at the front of the courthouse, there'll be a police memorial service. And of course, this year it's a little more important to us than it has been in the past. I'd like to invite anyone listening and all of the board members to attend that service.
Thank you.
What time is that service again?
I think it's supposed to be at 11 o'clock.
Any other new business to come before the committee? Mr. Kirkstra.
I would like to make the motion to be adjourned.
Ms. Peters?
Second.
All in favor say aye.
Aye.
Opposed, same sign.